and say, "Oh, I didn't see the right thing." They had her in a car with the police, talking to the police. She said, "Nope, he never told me I could not leave. Nope, he never had one." So I understand that there may have been some talk back and forth.
The sovereign citizen.
You filed all your paperwork to get some stuff set aside? Did you bring an order?
Did I bring the order like set aside itself?
Yeah, an order for me to sign. Do you have the order that I need to sign? Because I don't draft orders.
I put it in the court a month ago, and I gave it to the court, yes.
Was the order part of what you filed?
Yes. It's like the application for the set aside.
Application isn't the order.
They told me to go online.
I know. I just had this problem a month ago with another young lady. All right, so the good news is the prosecutor's not objecting to what you want. The bad news is it can't happen until I sign an order.
How do I get an order from someone else?
It's a form you got to fill out, just like the form you fill out to start this. It's a form you fill out, and you fill it all out, and then I sign it and date it. All right? No, I mean, I'm here, so it's no big deal for me. Just means you got to come back again. Or you can email it to us.
Attorney, I'm doing this.
No, please hold myself.
Okay, well, then you need to research. Yeah.
Yeah. We're going to help you out with an email address so you don't have to come back.
Yeah, if you the downstairs contact us, she can email it to them.
Okay. All right.
Yeah.
What do you got?
Randy Toombs, Your Honor.
Toombs, T-O-O?
I have it right here, Judge, for, he was supposed to come in with, his calendar.
It's August 11th.
I don't.
Okay.
August 11th, I have 10 a.m.
Sounds great.
All right, I will get Mr. Toombs a notice, and this is gonna be Mr. Lamb that handles it, or is it? All right, I will get Mr. Toombs a notice and he can get out.
I'm just going to keep him saying, oh.
He was saved. Heather. Yeah.
Do you have another one, or?
One that you actually.
That's it. Okay, yep, so we're good. Mr. Riggins will be on Mr. I will bring.
Thanks, Jim. All right. So remember, this is it. We ready to drop it outside, it's just on.
On which file, counsel? Mr. Clark?
Yes.
You're right, Mr. Clark. We're just waiting till we get all the attorneys in the room.
Okay.
Mr. Mohammed. Yeah, we got him in person though. Counsel, what are we going to do today?
Mr. Lucky's anyways.
Oh, it is? Oh, great.
On page 5.
All right.
And you have both paper and discovery.
We've currently got an exam scheduled next week. Does that work for you? On the 4th at 1 p.m.? All right, so let's just leave the exam as is and talk about bond. Mr. Lucky, this is your file?
Yes.
All right, so currently bond is 100,000, 10%, no contact, no release without GPS tether. We agreed? That's what the ROA says? All right, go ahead.
Yeah.
Hold on, did you put your appearance on? Did I get that? Go ahead.
Hey, good morning, Your Honor.
Good morning, Your Honor. Good morning to your staff and your defense services by Ken Riggins, D82125. On behalf of this Kevin Parks will appear via Zoom.
You can hear us all right, Mr. Riggins?
I
Mr.
can't
Clark,
really
you can
hear
us all?
No, not that good.
Okay, so far all I've got is the attorney's names on the record.
Okay.
And the fact that your exam is going to be next Tuesday at 1 p.m. You got that?
Yes, sir.
I'm having a lot of trouble with my courtroom audio this week, so I'll try to translate. If you can't hear, I'll let you know what we're saying.
Okay, thank you.
I'm sorry, go ahead, Mr. Perkins.
The top charge in this case is a computer felony. It is a police officer resisting obstruction. I haven't done the guidelines. I imagine the guidelines would very well possibly probation. He is a half more, I will not that deep. There is a firearm that's got busted on in 2025. He's already served time on that. Other than that, this is not a case where I can see how a $100,000 bond is. I do know there are allegations of former girlfriend, but I know this charge never came to fruition. She said that didn't happen. He never had a gun. He never held her cat. Based off of what I see, my client was. This was an argument that that came out of hand, and next thing you know, there was a bunch of SWAT cars at his house. Client became scared, did not want to come out of his house because there was guns pointed at him. But nevertheless, my client does not have to play to a peer history. My client has family, community time. He was working prior to this. He was working for a bottle manufacturer. Unfortunately, he does not remember the name of the bottle manufacturer. He intends to get out and go back to work as soon as he gets out. There's a health provision. My client has no reason to be the ex-girlfriend. He's just asking that he can give him a personal bond where he can go stay with his family and appear in court and fight his case.
Mr. Leckie.
Given the original already had this argument in front of the mark and you set the original bond. At that time, we laid out the facts that he was a threat to police presence that was there. He stated on so they the fact that I'll shoot any face that comes in here, threatening lives of officers to the point where they had to call the SWAT. And so 2 hours later, SWAT took the scene. Another hour and a half after that, message negotiation, the complaining, one of the complaints, the female complaining witness, the incident partner, came out after that time, and then after a month of time later, the defendant came out. Now, this caused the rounding split of the police department and Western Plain County SWAT total of about 6 hours. 6+ hours in order to effectuate his coming out. He did threaten to shoot officers, and there's camera footage that the news picked up of him almost like grappling with SWAT as if being taken out of the building, wrapping his legs around one of their heads, pulling them down. He came to anger police to community was listed for police officers. We also do believe something when this is afraid before. I mean, I have been unable to contact her from this police unable to contact her. It's a very fearful situation that we are all in. So therefore, Your Honor, because of the Atlantic machine circumstances, the Atlantic machine facts that we have on the record, I think the bond is appropriate.
Yeah, go ahead.
A couple points. He said something about they checked the house. There were no weapons. There were no guns. The girlfriend said there were no weapons. And this isn't where she was with him and said, oh, I better say the right thing. They had her in a car with the police, talking to the police freely. She said, nope, he never told me I could not leave. Nope, he never had a weapon. So I understand that there may have been some talk back and forth from police. He never had a weapon. He never threatened her. She came out and said, she's not here because I looked at the body cam footage. It is very clear she did not want to move forward with the case. So much so, she thought they were crushing her. She told them, I need to talk to my own attorney. So I think it's a little disingenuous to say that she feels threatened when she was really annoyed. But nevertheless, Your Honor, again, the top charge here is a 2-year felony. I don't think that it's appropriate to have a $3,000 bond based off a 2-year felony. Again, this man is working. He wants to, he has a story he wants to tell.
Anything else?
So, I did read the part of the transcription of the hostage negotiator as well as that body camera insert. She does say that he physically kept her in the room, physically locked her in, was pushing her inside the room, held up a sign that said help. Whereas the police officers came in recover, and she was at one point the negotiator does, after the 3.5 hour mark, she does refuse to come out, saying he's the one that is. But she does say during those 3.5 hours that she was kept in the room, forced there, felt afraid to come out, and eventually had to sneak out and live the bathroom or another. So I don't think it's such a thing, so but I'll leave it. And again, there's no facts here that are linked to what the bond was set at, so I think the bond is appropriate.
Okay, thank you, gentlemen. No doubt, 100,000, 10% is a pretty high bond on this, but we usually don't have SWAT involved on these types of cases either. I'm gonna leave the bond as is. It's only 1 week. Thank you, gentlemen. Are we done or we got somebody else to jail?
And this is for Tuesday?
Mr. Clark, yeah, I'm leaving your bond as is. Your court date, next court date is next Tuesday at 1 p.m. When you talk to the deputy, would you tell them we're ready for Mr. Slade, please?
Okay.
Thank you. Thank you, Mr. Ferguson.
Asked not to get out of in custody. And play at 9:30, please.
Oh. Trays and stuff, okay, yeah.
The Sovereign Citizen.